Well, hello and welcome back to the video series, the signing video series that we are doing. This video specifically is going to be about the financial power of attorney. So we are going to discuss the financial power of attorney for Mark Smith, which will mirror very similarly to your documents that you have in front of you. If you're married, it will mirror almost identically. If you're a single individual, widow or widowed, it'll be slightly different. Primarily in the last paragraph is going to be the biggest difference, and I will definitely highlight that just so you're aware. But otherwise, they will read almost identical. Just a reminder, the financial power of attorney, I truly believe is the single most important document that every individual over the age of 18 years of age needs, so that if you lose capacity, somebody else can make financial decisions on your behalf, pay your bills, make sure the rent and the mortgage get paid, the utility bills, the phone bills, the cell phone, all that stuff. And people underestimate it. The key is getting it done while you still have capacity. That way it is valid at the time that you need it. Couple just overall arching comments. You will notice at the end that there are acknowledgement pages where your power of attorney will be acknowledging when they are ready to use the document that they will not commingle their assets. They will act in your best interest. They will, certainly take to the extent that you're able to express your wishes, follow your wishes. We are not going to have them sign it until they need to use it, which is something that we discussed on the authorization and notice video. And I just wanted to highlight it before we start into the document. We do not need them at signing. We do not need them to be there with you because we're not going to have them sign it yet. If you are in a situation currently where you do need someone to act on your behalf today, please let the attorney know in the one-on-one attorney review meeting. But honestly, we still won't have them necessarily sign the same day that you do. Their signatures do not have to be notarized, so we can just have them sign it once the documents are executed and notarized. All right, so I just wanted to make sure that I started with that. And then, of course, we're going to hop into the document. So I will share my screen. Again, this is the financial power of attorney for Mark Smith. This is the cover page. The notice page is a legislator document. This is not from me. This is not from my office. You'll notice it's all caps. I don't type in all caps because I was told and taught as I was growing up that is screaming. So that is definitely not from me. This part and the acknowledgement that is at the end of this document are all PA legislated forms put out by the legislature in the state. And essentially the notice part here is just saying you are giving broad powers away. The person who has this document and who is named can transact business on your behalf, make decisions on your behalf. So just, be aware of that. Obviously, that is what the document is. That's the whole point of the document. But my understanding and my guess is that a case occurred where somebody said, well, I didn't know that he could write checks out of my account. And so the legislator said, all right, well, we're going to make sure that you know, and you have to sign something acknowledging that you know. This really doesn't tell you anything about what the document says or who's being named. It just simply says that you understand that you're giving away powers and that they can act on your behalf. Now, that is part of the reason why we're going to keep this document protected. We're going to leave it in the office, which is the other form that we had you go over and review. The authorization and notice page is that we cannot give it out until you tell us to do so or you're incapacitated. You will sign at the bottom of page 1. Now we get into the document. I, Mark Smith, appoint my wife, Sarah Smith, and she is my agent. Now, if you see under Article 3, we have successor agent listed. So if Sarah cannot act, we then have Dan as the backup power of attorney. And if Dan can't do it, then we have Reese. So you'll see that it's in that order. One of the things we talked about in the blueprint meeting is that we probably do not want to name two people under the current laws and under the current banking kind of structure that we have in Pennsylvania in particular, but really just across the country. Banks are going to electronic banking, which means nobody is physically looking at the checks. So when you list two people and say, and that requires two signatures. because they're not looking at the checks. They don't want that anymore because they don't want to be held liable. So if you say or, it could be Dan or Reese, but they will not allow you to say and. So we did everything we can to try to discourage you from doing that. We talked about it in the blueprint. If you do notice that it says and that both people have to sign together, please bring that up at your one-to-one attorney review meeting. I'd like to change that to either or just pick one. One of the lines that I use in the blueprint is let's just pick a winner now. And then that way we know who's responsible. We know who to look to. If you say or, they don't even have to talk to each other. And I don't like that. So I would prefer we pick one. But if you are going to name two, we are going to have to say or on the financial POA. Under Article 1, it is durable. That only means that if you become incapacitated, it's still a valid document. That is all that it means. It doesn't mean anything more than that. And of course, that is the point, right? That if you become incapacitated, the document is still valid and that you can name someone to act on your behalf. Article 2, it's effective immediately. This is why we're having you sign the authorization that they can't take it out of the office unless you tell me to do so or you're incapacitated. That's one of the mechanisms that we use to keep it protected away from desperate people. You might have heard this before from me. Desperate people do desperate things. If you give them the document ahead of time and they lose their job, they go through a divorce, something catastrophic happens in their life, giving them the document, it just allows people to think of things and justify things in their head. We don't want any of that. We just want to make sure when we need them to use it, they have it, but not when we don't need them to. So we'll keep that protected. Article 4 is where grant of powers start. What is it that you're giving the agent to do on your behalf? Anything and everything that they need to do. Whatever you can do as an individual with a valid ID, they can do for you. It is literally that broad, that comprehensive, and it needs to be because we don't know when you're going to lose capacity. We don't know what the situation's going to look like. We don't know what you're going to be, your health, the circumstances. So we have to make this as broad as possible. What makes it as broad as possible? The powers that are granted. Each paragraph that you will see coming up is what makes it that way, because that's what it says. Not because we use the word general, not because we use the word durable, because we actually specify specificity of everything that we need them to do on our behalf. Now, in the old days, those bold headings there were all that we would have. It would be a page and a half of just 27 listings of items. And then case law came out and said, nope, that isn't specific enough. You need to state with specificity every power. So here we are. You'll see that there's a heading and then it's blown up and really, really kind of specified. I would spend less time looking at the specific paragraphs and more time looking at the headings, because the specifics are just there for the banks and for the details. As long as you understand that they can do anything on your behalf, particularly everything that is covered in those headings, that's what I need you to understand for now. It will go through each one in detail, engaging in stocks, bonds, and other security transactions, real property, buying, selling of real estate, hiring and entering into contracts to improve it, to build on it, to transfer it, to collect proceeds, rent, sales. Everything is covered under that. Settling lawsuits, compromising on behalf of the principal, whatever you need to do to enter into alternative dispute resolution, ADR, settle things in court or out of court, whatever needs to be done, the agent has the authority in regards to settling of lawsuits and compromising. Tax issues, whether it be with the Department of Revenue, Department of Treasury in Pennsylvania, they have the authority, if there's an issue in regards to taxes, to be able to transact business on your behalf, make decisions on your behalf, and settle those disputes, or simply just negotiate with them. Retirement planning transactions, making changes to beneficiary designations. Now, this is a great time to sort of make a general comment. One of the things that I hear estate planning attorneys say is that the problem with these powers of attorney is that they're broad. Absolutely, they have to be. Unequivocally, you want it to be. If it doesn't say it in here, we can't do it. Their concern is, well, if you give somebody the authority to do this, they can go carte blanche and steal from you. No, 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 it doesn't say that. Everything in here says it must be consistent with our prior gifting planning. It must be consistent with my estate planning. It must be consistent with everything that I have done. So no, it doesn't give them carte blanche. They are a fiduciary. They are held to a higher standard, which means if they do take money for themselves and it's not consistent with the plan, they will go to jail. They will be held liable, right? Don't worry about your kids. That isn't an issue you have to worry about because they're not going to do that. But I just want you to know that if they do, there are consequences to those choices. And because they are held to a higher standard, the courts will certainly come down on them harder than they would an individual who is not held to a higher standard. That standard is the same standard that an attorney owes to a client, right? It's a fiduciary relationship. So just because they have this authority, it is very clearly must be consistent with the estate planning, pursuing benefits, Medicaid, Medicare, Social Security, VA, insurance transactions, electronic and digital assets. Again, getting access to Netflix, to online accounts, to Facebook, to Twitter, all of those as well. Paragraph 11, specific powers defined by statute. Gee, Jeff, all of these have been stated elsewhere in the document. Yes, they have. You are correct. Jeff, why are you repeating everything you've already said? Here's the reason. A confused mind always says no. So if a bank teller is expecting to see right out of the statute certain paragraphs, that's what they're looking for. If we don't do it this way and they're looking for these paragraphs, they're going to say it's not in here, even though we know it is. So not only do we name it somewhere else, we also put it here again, and we just list it from the statute in case that's what they're looking for. Unlimited gifting. Again, this is unlimited for the purpose of asset protection, asset preservation, Medicaid planning, long-term care planning, must be consistent with your estate planning, and it's only to your family, children, grandchildren, spouse. So if you don't have a children, grandchild, or spouse, make sure you bring that up at the one-to-one attorney meeting because we're going to need to extend who we can give it to. Generally speaking, we only list spouses, children, grandchildren so that we're keeping it in the line, which also does protect you. But if you have somebody outside of that, we'll need to change this paragraph to include them. Again, the purpose is specific for qualifying for benefits, not for stealing money. If we need to do special needs trust planning, we have the authority. If we need to create irrevocable trust, we have the authority. Gee, Jeff, isn't that what we're doing here through this process? Yeah, maybe, probably, yes. But what if we need a different trust? What if we still need to amend the trust? What if we need to do work on the trust? I just put it in here because you don't know individual circumstances. What if you revoke this one and you choose to do another one later, right? So we're just going to say irrevocable trust as well. It is power immediately and does not lapse at a certain point in time. It will lapse when you die. Confirmation. This is everything that is provided for in the agreement and what it is that they have the authority to do. It can be revoked. Same capacity required to create it is the capacity required to revoke it. You can rely on this document if you are a third party, and a photocopy is as good as the original. Now, I'll be completely honest with you. Banks and financial institutions are not going to accept that paragraph, but I have it in there because in the event that we end up losing the originals because a person does something with them, it is possible that I can ask a court to force someone to accept a copy. Without it being here, I think my chances of getting that are very limited, but I don't want to give you a false hope that they can just use the copy. I have been told that some institutions have accepted it, but for the most part, they typically won't. They want the original. But again, that's in there just to be careful. Power to sue third parties who fail to act. So one of the things that the Act in 2015 sort of changed is if this is a valid document and you don't accept it unreasonably, you can be sued. We've never done it. We've never actually used it. but it certainly is a threat. And every now and then, if I'm talking to a bank and they want my client to sign their individual financial power of attorney, I always tell my client to sign. No reason not to. However, if my client did not have capacity to sign because they lose the ability, I'm always quick to say, I'll have them sign now, but please understand if they lack capacity, I will have to sue you under this act because you're unreasonably withholding the use of it. And they kind of laugh and say, well, if we ever get to that point, we'll deal with it then, but they have capacity. So just have them sign. So it is in here basically as a threat and is also under the statute. So we're allowed to say that. All right. Next thing. Oh, I went too fast there. Compensation. The agent can always be compensated, certainly can always get out-of-pocket costs, but is allowed to be paid. Most family members would not do that. Professionals will. It is required to have it in there that they can be if they want to be. If for some reason we end up in a courtroom in a guardianship hearing, which hopefully we never will, and that's why you have this document and your healthcare power of attorney in place. But if we are, this just says, unless this person, my agent, steals from me or does something horrible, please take my wishes and appoint those people. It's just another kind of reminder to the court about what your wishes are. And this is the section that will be different if you're not married currently. This is saying that my spouse can commingle assets. One of the things that you're going to see in the acknowledgement pages is that they agree that they will not commingle their assets with yours. Obviously, if you're married, they're already commingled. We're not going to make them uncommingle them. They can keep them in the joint accounts the way that they currently are. Then you're going to sign here. We, of course, will witness and notarize. The acknowledgements are going to be on the following pages. And again, just as a reminder, we are not going to have them sign this at the time of signing. If you need someone to act on your behalf now, please let the attorney know in the one-to-one attorney review meeting so that we can make a note. But even then, we don't need them to sign it when you do. Their signatures do not have to be notarized, only yours does. So the important thing is we get you to sign it, we get yours notarized and executed and copied, and we'll go from there. All right. And of course, there's Sarah's. The next one should be Dan's. And then the one after that should be Reese. There you go. So I hope that this video helped in regards to the financial power of attorney, document authorizing another individual to make decisions on your behalf if you can't. It is effective immediately. We are going to keep the original in our office. If for some reason you need it to be used now, let us know and we will give one original out and we will keep one. That way we always have a backup on file that's an original that we can use if we need to. We do not have to have your agent sign now. They only have to sign when they're going to use it. If they are going to use it now, we'll make arrangements to get that signed after you have signed and the documents have been executed. I hope this signing video series is helping. I hope that the financial power of attorney makes a little more sense. Please be sure to write down any questions that you have for the one-to-one attorney review meeting. And thank you guys so much.